I should stand here, right?
Yeah.
Thank you for the floor. I'm going to talk about essentially three things in this speech. Firstly, about what we think is a key purpose of trial, which is to get information and how the right against self-incrimination obscures that goal. Secondly, why we still think the right does have a place for certain groups of people and why we think it should only be revoked for those with private counsel. And thirdly, how we think there's some unfairness going on in the justice system and how this motion helps address some of those injustices. So, diving straight into the first point. So a key purpose of trial is to get information, to find the truth of what has happened, right? And allowing withholding of information will typically obscure the truth, right? This is particularly true because we're talking about someone who's quite central to what's going on, namely the defendant, right? This is typically someone who will have particularly specific information that no one else will have, will be especially important in terms of finding out what actually happens. So withholding this sort of vital information, like preventing kind of probing into the, like this person, questioning them about what they did, etc., is something that will sort of prevent us from knowing exactly what happened. But we think this is less true for those without private counsel, right? Because we think that those without private counsel are more likely to face a sort of asymmetric power balance in the court system in terms of actually getting the truth out there. I'm going to get more into that in my second point, but I want to mention it already now. So also, when is it particularly important to get information for the public to find out what happened? Well, I said this is especially true when a case has some kind of systemic impact, when it sort of spreads beyond just the people directly involved in the case and has some kind of wider implications for society as a whole. Things like, say, political corruption. Things like, major finance institution scandals. Think Enron. Think, our Lehman Brothers. Like, when those kind of things happen, we say that there's particular interest for the public to actually get information. And note that the kind of defendants you have in those cases are ones that, without a fault, will have access to private counsel, will pretty much always have access to those kind of things. So we say that in those cases, it is particularly important to actually get information, because the implication goes beyond just that case. There's legitimate societal interest in finding out what happened in those cases, because we need to know that for the future, how to, for example, regulate the banking sector, how to handle things like lobbying or money in politics, etc. There are a lot of third parties affected that sort of have a right to get to know what actually happened. So essentially we say having this motion is something that will give more information, more truth. When we have more access to what actually happened, we're more likely to be able to construct good policy in the future to prevent bad outcomes. So I think that's something that in general makes society a better place, allow us to do better things and achieve better outcomes. So secondly, so why should we then have this right at all? Right? So we already sort of hinted that this is something that we think tends to apply in most of the cases where you have private counsel. Right? Most of us say the justice system sort of have a lot of insiders on the prosecution side, in terms of the police, in terms of prosecutors and so on, but have a huge structural advantage against sort of the random person from the street. And we say that when you don't have private counsel, when you have public counsel often have quite weak incentives to engage in your case, right? They don't really, they're not getting paid by you, they're not dependent on how good of a job you think they did when you're the defendant, right? There are some exceptions to this, like, there are high-profile cases where, you might, as public defendant, get recognition from doing this, but those cases are quite rare. The vast majority of cases where you have defendants who can't afford a private counsel aren't high-profile cases. So in most of these cases, this doesn't actually apply. So in the vast majority of cases, you're going to be quite disadvantaged against the police, against the prosecution, as someone who doesn't have private counsel. And we say that for that reason, we have cases where those people typically have low societal impact as well, right? There's an unfair advantage. We're saying that giving them people right to not implicate yourself. When you get asked tricky questions by the prosecution, questions you don't, or by the police, questions you don't really fully grasp what they're about, you don't have access to a really good privately paid lawyer who can help you answer those questions in a way that helps your case, then in those cases that right to not incriminate yourself is an important right. It's something that gives people a decent shot even though they can't afford private lawyers. I think that right thus is important, right? We think like the information that you sort of get out can then easily also be manipulated against you. So in those situations, because of that structural disadvantage, it's less likely as well that it actually leads to getting the truth out. it's more likely that it simply ends up hurting you as a person. Sure.
So how is it justified to make a definitive deprivation of rights for one segment of community for a presumption that you're making on the quality of lawyering between public lawyers and private lawyers?
So we think, first of all, it's kind of self-evident, right? Why would anyone ever pay a private lawyer unless they were better, right? So we think that it's like very plausible that on average private lawyers will always be better because there wouldn't really be a market for them if they were just as good or worse than a public lawyer you get for free. So we think that like that's just like very likely generally true. In terms of why it's fair to like have different sort of laws for different groups of people in this case, it's actually what I'm going to get to pretty much right now. So my third point is about unfairness in the justice system, right? So, I also want to say before I move to that like we think also like when it comes to this right, we also want to point out that we think it specifically will tend to help people who are innocent, right? In terms of like the right to not self-incriminate is typically a good right if you're guilty, because then you don't want to incriminate yourself for the things that you did. Whereas if you're innocent, like getting your story out, especially if you have access to a good lawyer who can help you spin that right, is typically something that helps you. So there's also something that on average sort of helps the right kinds of people for that reason. My third point is about like unfairness in the justice system, right? So we said that basically people are often rich or poor. Sure, go ahead.
Yeah, so how do you think this impacts the evidentiary standard that prosecutors have to deal with when dealing with defendants?
Yeah. Well, I'm not sure exactly what you're referring to since you really elaborate what you meant by evidentiary standard. We think that it's generally fine to have other kinds of justice system work similarly. Okay, so that people are very often rich or poor due to factors beyond their control, right? I mean, say that in that sense, being rich is something you don't necessarily have to serve. And the rich can get good lawyers. They can often like sort of use that to talk their way out of criminal cases. So on average, this leads to poor people being more likely to get convicted for crimes, even if they have sort of the same rates of being innocent or guilty. In a society where we're supposed to have equality under the law, this is kind of a bad thing. I'm not saying this motion is a perfect fix to all of that. It's always going to be like, it probably can't be fixed completely, like people with money and power will always have some ways of getting better off, but at least it does something right. If you have the privilege of being able to afford private counsel, you lose another right that's supposed to help you in situations in the justice system where you are at disadvantage. We think this is something that makes the justice system a little bit more equal. It equals the playing field. To some extent, we think that's a good thing. It makes the justice system a little bit fairer in a situation in status quo, but it really isn't fair, and poor people tend to face a lot more convictions for reasons that are really beyond their control. For all those reasons, we're very proud. Thank you.
I thank the speaker for his remarks and call upon the Leader of the Opposition to deliver her subject matter address.
Yes.
Thanks.
Panels, note that in the world that government is describing for you, they paint you a picture of two things that they assume about court cases. One, that most court cases are somehow, in criminal courts, contested between extremely wealthy and extremely poor people. I don't think that's the majority of cases. I think that, especially in the cases of marginalized people they're talking about, it's probably two people who can't avail themselves of a private lawyer, so I'm not sure if that impact is even relevant to the case. But the second thing that they tell you is that this is really important because trials are where we find out the truth about things. I want to talk to you about why this right is important in trials specifically, what the purpose of trials are. I would argue that it is in fact not for finding information, but for evaluating what information we have. And then I want to talk to you about evidentiary standards, what incentives this places on the people involved in trials about those standards, before I get into refutation. So a couple of things about this right in particular. Look. We collect evidence pre-trial. We do this because trials are dubious in a number of ways. When you are on trial for a criminal offense, you are not on trial purely for the evidence. You are often also on trial for your social circumstances, for the groups you belong to, for the associations you make, and that is often a set of conflating factors that either side of prosecution and defense use to spin court cases to their advantage. Islam and I won't contend that there isn't some kind of spinning happening, but we will say that it happens on both sides of the house, that the prosecution and the defense are as likely to use all of the conflicting elements of evidence to their advantage. I think that that's one of the reasons why this is a particularly unique and important protection for people on the defense side of a criminal case. Why? Because the consequences of going to jail, regardless of who you are extremely large, right? So when they tell you that this is only going to be used in the cases of people who are guilty. I think that that's actually not the case. Why? I think that it is also something that is used for people who don't want to incriminate themselves for further or other charges. Recognize that people often use evidence brought forward to find new things that they should be able to prosecute, to consider the direction in which prosecution should go so that they perhaps ask for a different penalty or change the direction of their strategy. I think one of the reasons that we afford people the opportunity to not self-incriminate is because it opens up many, many unfair angles to the people prosecuting them to find new ways to exploit the evidence that there is no comeback from because you're the one that gave it, right? Recognize that the reason that we put such a premium on the defendant as an information source is we assume that they have the heaviest investment in this trial. That means that no matter what they are forced to say in questioning, it is going to sound to the prosecution as or to a jury if there is one, as the most reliable piece of evidence, whether or not there was a trick question, whether or not they had all information available to them in prep before the trial. I think that this part of a number of defenses against prosecution, not least of which reason we care about it, is because people shouldn't be led to incriminate themselves for more than the crime they are on trial for, and that is often the end goal of these prosecutions should back have.
So tell us why, when you have a plethora of lawyers advising you, you should retain that right at a similar level to someone who has no access except the state lawyer provided.
Okay, so a couple of things. Not everyone that hires these lawyers hires them because they're just like making bank and think that it's like a great idea for them to spend that money on a lawyer. Many people invest very heavily in private counsel, particularly because they are already the least advantaged and are the most likely to suffer the consequences should they go to jail and forego mobility rights, should they go to jail and forego the economic ability to mobilize themselves, right? Like the people who are most likely to suffer when this right is taken from them are the people the odds are stacked against pre-trial, and they use the right against self-incrimination to keep themselves out of abysmal situations in a society that is stacked to lead them to jail in the first place. I think that many people make the calculus that like, oh, the jury is likely to prosecute me regardless of quality of evidence. I'd like to invest in private counsel for the number of pieces of advice that they avail me of, in addition to the fact that I already have this right in common with anyone else. So what does this do to evidentiary standards then? I think many prosecutions will now turn on testimony to an even greater degree, and it degrades the way that we consider evidence in the courtroom. Why? Because the most compelling thing you can do now in court is say, well, look how wealthy this person was, regardless of whether that's true. Point out that they've hired counsel and say, you know, disregard the other facts. Think about the fact that I led them through a series of leading questions that not even their high-paid lawyer could prevent, and then they had to give me evidence that sounds like they're guilty. Like, recognize that this places a heavy incentive on prosecutions to sway things so that juries are led to believe that the thing they should most consider is testimony over evidence, even though we are well aware of the many conditions under which testimony is subject to great bias or unpredictability or unreliability, even on the part of someone who was involved in a crime. There are memory lapses, there are leading questions, there are planted memory, like there are a series of things that make memory the least reliable measure we should use in courts, and we are taking away the right of people to protect themselves from the way that that visits harm on them in the case of a trial. Why is that particularly bad? Because trial is not the point at which we are the least biased. Trial is the point at which all evidence has already been collected by as impartial people as we can get, and then is spun by either side to say, this is what it supports. I'll take you in a second. That's the reason that when open government tells you trials are about finding the truth, that's not true. Trials are much more like a debate round in which you make it sound truthy on your side, given what you have, and that the evidence is the thing that you depend on to sway people. When we put a premium on spoken evidence, I think we shift the way we evaluate all the other kinds of evidence in court, even if the physical evidence is more important.
But any evidence can be spun. What we're doing here is we're allowing all evidence to be taken into consideration. On average, evidence will be better than just excluding certain pieces of evidence from even being considered in the court case.
Okay, so this is where I want to get into refutation, because I think that they set up a very, like, a deeply unproven set of assertions on opening gov, and they're just like, man, like, court cases are where we find out the truth, and we would never get this information otherwise. So recognize that that's in tension with their assumption that this is so obvious that all they're doing is really hammering it in, and this person otherwise is pretty guilty. Like, if they are that guilty, I think it's probably important that we don't hinge their guilt on the idea that they confess to it. There are a lot of reasons why I think that that's bad. But secondly, when they tell you that there's an asymmetry of power in the court, this is saying that there generally ought to be worse trials, right? Like, recognize that they tell you this will be a head-to-head of two poorly skilled or underpaid or overworked public defenders. That's not just bad for the person on defense, it's also bad for the person on prosecution, because now it hinges on who is a slightly less crappy lawyer, or who has slightly slightly less work that week. So it's like, now we should have this right taken away from us on prosecution only so that we can match how overtaxed the legal system is. Like, they're adding pressures to a legal system they say is already bad at doing its job. I think that that's pretty harmful. Then they tell you public defenders are just not as engaged in your case. Right. So in the absolute worst case scenario, this is someone trying not to get the harms of jail visited on them. They want to take away their right to have anyone competent or invested in their case, when there is a system that already says there are many social factors that probably lead to you being found guilty. I think it's harmful when people make a significant investment to take away their right to believe that they themselves are innocent. Very proud to close.
I think the speaker for remarks and call upon the deputy to deliver his summary address here.
Okay. Fundamentally, we think that the opposition has agreed on the main ideas here, which is that what is trials about? Is it about finding truth or not? And we agree with their assertion that when it comes to sort of defenders' counsel, when it comes to the prosecution, it is an adversarial system. It is like a debate round. But when it comes to the actual judges, it is about finding the truth within that round, finding the information of what actually happened. When it comes to the juries, they have to figure, is this person likely to be beyond reasonable doubt guilty or not? That is a truth-finding mission. That is not about, oh, was the other person more persuasive or not? No, the question they ask themselves is, what do I truthfully believe to have happened? So I'm going to do some actor analysis about who benefits and who doesn't from this, and also look a bit into this principle, does this information benefit? Because they seem to, on their side, take a principal case that the person, the main person, sort of main involved person's witness testimony is bad for trials, that shouldn't be used at all. It seems to be the case coming out of their side. So before that, I'd like to talk a little bit about who gets private counsel and how public counsel works, so to speak. Well, first of all, we think that public counsel is usually worse than private counsel for the main reason that they're overworked. Like, they have 30 cases compared to private counsel might have 1 case, for example. But who then gets private counsel? They seem to say that if I believe that the courts are stacked against me, I belong to an ethnic group that are, considered to be more likely to make crime, for example, and I feel that it's more likely for the jury to want to put me in jail than somebody else, that motivates me to get private counsel. We don't think that's true. We think everyone's motivated under the current system to get private counsel because private counsel is, for the reasons we've given, better. So it's mainly a component of if you have the money or not. For the simple reason that there are no real cases, high-profile cases in the US, which we've more or less set this debate, because that's well, in the sense that it works completely different in Sweden. In there, we never see anyone in any high-profile case saying, no, I don't want to have private counsel, I wish to have the public one. It is never even the people say, I'm innocent of this, let me have the public counsel because I don't need private one. No, we think that when it comes to the benefits of private counsel, it always weighs in favor of getting them if you can afford it. So it's never a question of motives of the person being on trial, because they always fear jail. They always fear that the jury might come out against them. They always fear that the prosecution might spin something. So it's always a question of wanting to get this. So it's always a question of the rich people having access to it to a greater degree. Now yes, there are always gray zones, and there are always some people might take a loan to get it, but on the comparative, the people who don't get private counsel will always be the ones who cannot, for example, take that loan or for whatever reason get it, right? So what then happens? Well, the trial and the justice is about having competent judges and juries making calls based on as much and as possible information as possible to be available, right? And the reason for this is that so they from that can pick what likely happened in the case, in the scenario that is on trial. Did the person commit that crime? Was there a crime at all? Did somebody else do it? And we think that, yes, on that, there are always going to be 2 narratives. One from the prosecution saying the person did it, and one from the defense saying that for whatever reason they didn't do it, leading a different or various different narratives. But when it comes to making that call, it will always be in favor of the judges and the juries to have as much information as possible, presented in such a good way as possible. On their side, they would claim that, oh, the person central to this case shouldn't say anything because witnesses are implausible information. If that's the case on their side, then they would ban using witnesses in court, right? Memory's faulty. You should only use technical evidence. But they're not saying that. They're saying that witnesses have a preferred reason to have in court, not just when the defense wants to go up there and claim that they didn't do it in the cases that they wish to be, not use this right, that is, but also like third-party witnesses are useful in court. And the reason for this is because when it comes to judge of character, when it comes to judge of truth, it is very often good to have a person there and to see what they said and to be able to determine how they're saying it. I'll take over.
Yeah, just to be clear, your big turning point as to why it's okay for people to use public defenders is that sometimes they don't know how to answer the questions. Why can't that also be true for difficult trials where the prosecutor's actually good and you might just not know because your private lawyer didn't tell you how to answer it?
Excellent question. So, let's look at an actor analysis here. So, the principal witness, the source of most information, we don't think should be withheld. We think that information should come to light. In that sense, we shouldn't have this principle at all. So why do we have this principle? Why do we say that this principle should be in place for public defenders? Well, let's look at two types. We can categorize people in two categories. The poor who cannot afford a private defender and the rich. And those two people can be either guilty or not guilty. And if we look at the poor who can be innocent or guilty, why should we not put them up there? As we said, we have an asymmetrical power balance when we have the prosecution putting all their tricks, as you say, onto them, and they have inadequate public counsel to do anything about it because they're overworked or don't care or whatever. We're saying that that distorts the information, that creates a difference in narrative that you should have a right to withhold yourself from. Why? Because you have no way of sort of getting out of it, and because we don't think we should pervert justice in this sense. I'll take back half if you have it. No? Okay. But if we look at the rich, you're saying that they'll be completely at the mercy of the expert prosecution. Well, first of all, we don't think that's necessarily true, because prosecution, just like public defenders, often have a lot of cases as well, whilst the private counsel usually only has this one case or very few ones. So again, you have a slightly asymmetrical power towards the private defense counsel there. But secondly, they will be on par when it comes to legal sort of sassiness, and when you can thus allow yourself to be coached by your private counsel, when they can tell you how to tell your story, how to avoid the legal tricks. Yes, in some cases they won't be as good as prosecution, just as in other cases the prosecution won't be as good as the lawyers. But we're saying in general there'll be more an even balance. But what does this mean to be able to refrain from this? Is that when you know that the story won't benefit you, which is most likely a guilty case as Gustav brought you, then you will use this right to say, I'm not going to talk at all, because that's in disfavor. Whilst if you're innocent, you'll be coached by your lawyer, and they will say, put up a good story, tell your story to the jury in a plausible way that they'll know that you're innocent, and thus you'll be better off and able to get clear of this trial. We think that that asymmetry is bad for justice, and for that reason, we're proud to propose.
Okay, distinguished members, remarks and call upon the deputy leader to conclude the front half of this round debate. Here.
Honorable Speaker, the opening government case thus far relies on the fact that the way in which people who are going to incriminate themselves will answer questions about self-incrimination is going to be truthful and is going to lead you to information that you want under the status quo. I don't believe that's true under any circumstance, and I think it can possibly also subvert the justice that you could get from that trial in the way that they want to deviate that conversation, if truly what the answers that they will be giving you are going to incriminate them and get you the justice that they want. That's something that I just don't think that you get the efficacy that they need in order to win that argument. And then I'll deal with extension. So first, why? So people who are going to self-incriminate if they answer a particular question under the status quo have a couple of incentives. They don't want to commit perjury in case they are found to be lying, so therefore they're not going to answer the question because they know that they're going to incriminate. If, however, the alternative now is that you have to answer, I think that probably you would trade off the likelihood that you might be found out to be lying, because the kinds of things that are needed to be proven in that particular trial haven't been found yet, right? Because they're dependent on your particular testimony. I think that therefore this gives the incentives to those particular criminals that might be incriminating themselves to actually answer in a way that is either not truthful or is misleading to the vast amount of individuals. And I think that you're placing a premium on whether or not this is going to be something that is going to be truthful. What I think that then does is removes the incentives for those particular lawyers to focus on other witness testimony or other physical evidence that I think is oftentimes just simply more objective. Because oftentimes what this can end up doing is it means that they're going to answer in ways that will perhaps obscure the way that the trial is going. So perhaps point to somebody else that could have been, point to somebody else that they think could have been doing it, say they didn't do it, and you actually just don't get the objective fact that they are not willing to answer it, which leads you to focus on other things. So I think it just confuses the whole process and oftentimes can lead you to things that don't end up being true or truthful in any circumstance. So I'm not sure why an individual who is going to incriminate would answer that question. I just don't know what the incentives are for an individual when they're going to get convicted or when it's likely that they're going to be convicted of a particular crime. Yeah, go ahead.
Sometimes juries need crucial information, like in an Enron crisis, when you ask someone, were you in the room? And they simply refuse to answer. The jury can't use any other information except the information from the testimony.
Yeah, but why would you say you're in the room? If it's really so bad for you to have been in the room, like, why would you say you were in the room? I literally do not understand why a person would answer truthfully or what the incentives of that person would be, at least not to obfuscate that or say or give an unclear answer to the point where I don't think it's just that you don't get the information you want. I think it actively gives you misleading information that I think oftentimes in testimony within court cases can be a bad thing. Like, you should prefer that you do not know or do not have the testimony from that person rather than placing an idea that this is going to be truthful or useful to you, which I think can oftentimes just take the trial much longer. Okay, so getting into reputation. First of all, they say the thing that we need in the justice system is we need to gather information and lots of it, and we should do this in any way possible. And really, here's a number of things that we say. On opposition, we say that there should be really, really robust protections for a defendant because the consequences of going to jail are so great. So there are a lot of people who do not know how to answer a question, regardless of how long they've been coached. Like, you might not know how to answer the kinds of questions that prosecutor is asking, or you might be, I don't know, freaking nervous because you're on trial for like something and you want to make sure that you're not answering something at that time. So you want to, say you're not going to answer it, go back and talk to your lawyer, and next time you're on the stand, perhaps you are going to answer that in this particular kind of trial. I think there should be protections for those individuals to make sure that they are answering in a proper way, because they might be worried that they're going to incriminate themselves when they're on the stand and making the judgment for themselves. But perhaps with coaching, they actually don't need to, like if it isn't actually incriminating, but the way in which they might answer in that testimony on that spot because they have to answer at that particular moment might be particularly bad for them. So I want all individuals to have the option to not answer at a particular moment in time, check it, or not answer at all, because I think Lex tells you that the consequences of going to prison are so great that we ought to be preserving the idea that people ought to be innocent and holding an evidentiary standard to be particularly high because of those particular stakes. Yeah.
So on the one hand, no one would ever incriminate themselves because that's stupid. And on the other hand, a clever prosecution might trick them into incriminating themselves. Which one is it?
No, I think you just should, first of all, okay, first, maybe you will be tricked, and that is bad for the reasons that I told you. And a lot of the times, you won't be tricked, and that is bad for the reasons that I told you. But oftentimes, you also should be able to decide what is the best answer for a particular question, both to serve justice of the trial at large, and also to serve yourself particularly. So, both of those things are possible, and both of those things are really bad for that particular individual, because the time when I think it would be useful for you to be able to talk to your lawyer is the time when I think your answer probably isn't going to be correct or useful. So then what they tell us is, look, the right is important for some people because they are disadvantaged because they do not have, private counsel. But here's the thing, their trials don't change under the status quo. You're not providing extra justice to people who can't afford a private lawyer. They have this right under the status quo. Their trials exist irrespective of this thing that happens to private lawyers. I therefore don't understand why you want to disadvantage people who want to pay for private lawyers. They say, look, everyone would pay for them if they could. I mean, maybe, but also like a lot of people do pay for private lawyers, even people who perhaps need to take out loans or need to get their family to support them because, as we say, the consequences of going to jail are super high. So I don't know why you're painting it as a picture of the wealthy in society are the ones who are able to obfuscate justice. No, I think that this is the greatest justice you can give, and I want all individuals who decide that that is a priority for them to have the ability to use this particular defense, because I oftentimes think that self-incrimination is one that is done either in error or in a way that we don't think is useful for that particular thing. So like their turning point literally in the case is whether or not you think it's fine or think it's critical in protecting a group of people who doesn't know how to answer questions. If I tell you that lots of people don't know how to answer questions and that this doesn't impact at all the people that they are talking about under the status quo, I really don't think that they get anything unique from that particular case when you come down to it. The last thing that they end up saying is, look, then why are you fine, and I think this came from POI to be fair, why are you fine with witnesses being giving testimony, but you're not fine with individuals who might incriminate themselves? Because I trust a person a lot more who doesn't have a stake of like going to prison to give me an answer in that trial that is either going to be useful to me or is going to be useful for moving justice forward in that case. Because the stakes for them is not I might go to prison if I answer, or if I answer in a particular way, or I might be found, or like it's not worth perjuring yourself if you are not yourself going to be incriminated. But for a person who is perhaps going to be incriminated, it is worth it. So I simply trust witnesses more, but I also think that they are more able to interact with prosecution and defense in a way that is going to mean that their answers are more useful to that particular trial process because they're not directly involved in the outcomes of that trial, at least to the same extent, and for which that is true, I think we can mitigate it, so it's a question of balancing. So on the basis that we provide the best justice, we match those.
Thank the speaker for remarks and call upon the member of government to extend the case for proposition by the chair here.
Sorry, Chair. Can we swap? Is that allowed?
Yeah, sure. I have no problem with that. Is that fine?
Yeah, sure.
No. Can I just step out real quick to the toilet? I'll just be back in the room. The debate can go on.
Yes. Let's go very fast.
It's okay, the debate can go on. I'll just
That's okay.
Should I go without her or wait?
Yes, that's fine.
It's up to you.
Yeah, what do you guys feel around? Do you guys want to wait or do you want to keep it?
It's just your call.
It doesn't
Is it my
matter.
call?
Speak. The floor is yours.
Okay, I'd prefer to wait.
Okay, cool. Let's do that.
Yeah, because
Oh no, I know. It would be weird.
Yeah. That's an embarrassing story about one time that I
It's just a nice little break in the debate.
It really sort of only makes the
Having a good
intermissions.
break.
We have snacks.
No, I don't blame
I
you.
felt it was appropriate.
I just like it. Actually, it's a very nice natural thing, like halftime of the debate.
I feel like everybody could use this time to kind of like revitalize themselves.
I think the judging panels will have like popcorn.
That'd be really good. Your notes would get so much better on them.
It's not.
You write your notes in
I'm
the
at the emergency room.
Still going, eh? It's a long emergency.
Real bad, man.
Just everything, just like teeth falling out, left, right.
That's horrifying.
You don't even have this. It's like my Stockholm.
I have to, because as a judge, I've had to run out to use the
That
bathroom.
lodge there.
I see. I have held it so long.
Thank you.
Okay. Right, so then, let's hear from the government extension now.
I think it's important for us not to forget what the standard is in criminal trials, which is what we're debating today. That standard is beyond reasonable doubt for criminal cases. And what often happens is that people who hire private lawyers hire them because they are better, but also because they are trying to get off scot-free. And there's one thing that lawyers are famous for doing. It's lawyering. It's staying as close to the black as you can to avoid being as close to the transparency of white, right? Now, why is it particularly problematic in these particular types of cases? The people who can afford to hire private legal defenses aren't your average mom and dad who are teaching in a high school. They would still, because of the exorbitant costs of private counsel, these are people with large amounts of money, and the types of crimes that they're normally involved in are high-profile crimes. So whilst opposition tells you that the consequences of going to jail are high, we ask you to recognize that the consequences of a criminal who has committed high-profile white-collar crime going off scot-free are equally high and arguably higher, because the public good is more detrimented when one guilty person goes to jail or possibly an innocent person goes to jail. That's one person. But if somebody who has committed a crime, like in Enron, when they were bribing and doing a lot of illegal activities, that crime affects a multiplicity of people. And we think that cost calculus is part of the imperative. Now, what we want to tell you, and this is our extension, and I'll incorporate a lot of my rebuttal, is we don't want a legal system where testimony is super coached, right? We think there's value to having natural testimony, and we think you lose some of that value when people can keep consulting with the plethora of legal defenses to make sure that there's never any real scrutiny of whether or not they have real guilt, considering and recognizing that the burden of proof is beyond reasonable doubt. All their legal teams have to do to get them off scot-free is to plant enough legal reason for the jury to suspect that there's room to doubt. And if they can do that, these people keep walking, and we think that's particularly harmful. And these lawyers specialize in doing that, and allowing people to keep refusing to answer the question doesn't allow the jury to examine and creates enough doubt. Because if you ask me, if I was in the room when the senator was taking the bribe and therefore I'm an accomplice, and I say I'm not going to answer because I don't want to self-incriminate, then you ask me, did you hear the conversation Bill Clinton was having with Monica Lewinsky? Then I say I don't want to self-incriminate. The jury never gets real ground to find out whether or not the offense was committed, and this in and of itself creates reasonable doubt, which gets the people who are being investigated off scot-free, even in cases where there is a prima facie case of guilt. Yes, ma'am.
Okay, but in those cases, your problem with this is standard of the burden of proof, and you're artificially trying to neuter those processes, because this only matters in the cases where those individuals would not be found guilty through other people. Why should it rest on their testimony?
All right, so we think that the standard of proof is high. We don't have a problem with the standard of proof. We have a problem with the fact that people who can afford a multiplicity of lawyers can abuse the standard of proof to get off scot-free. Now, let me explain what the purpose of a jury or a judge is, because we're happy to have this debate in any country, whether it's a jury or a judge, we're comfortable. The purpose of a jury or a judge is evaluation of the witness testimony. Is to examine the demeanor of the witness to verify whether this witness is being truthful or being deceitful. It's also to look out for inconsistencies in the witness testimony. You lose a lot of these attributes within the testimony if the witness is super coached, because now they are super coached to have the correct demeanor. They are super coached to have an escape clause for all of the difficult questions that they may be asked, right? So, if they are already being super coached and already have high prospects of getting off scot-free, considering the high burden of proof, why ought they have the right to retain another escape clause which exists because of the existence of this particular mechanism. So what you're saying to rich guys is, one, you have this unfair advantage. You've got a team of lawyers who can focus on your case exclusively for the duration of this particular trial. They don't have necessarily to be working on 6 or 7 different prosecutions or defenses at the same time. You've got the extra advantage of getting all of this coaching in advance. Simply put, we don't care that someone is nervous on the podium. This is not a good argument to say, hey, our client is nervous, so they should have all of these extra protections. Come on, there's a thing which is being tried, and normally these are criminal offenses, they're normally felonies. It's not the kind of thing where the argument of our client is nervous is good enough, right? So, what we're saying to you is, considering all of the protections that wealth affords you, why ought you to have another protection which makes it more likely that you're going to escape any conviction altogether for criminal offenses? This is why in status quo it is particularly difficult to get convictions of fraud in Wall Street, to get convictions of prominent politicians, because they can simply say, I don't recall, I don't want to incriminate, I don't, and this is why our justice system is failing, and this is why we're scrutinizing. This is the purpose of the debate, to examine whether or not we ought to continue to afford the wealthy this extra protection. And if we can, on a balance of probabilities, evaluate that them having this extra protection is no longer worth its weight in salt, this is the purpose of the debate. It's not enough just to say that we've always given it to people. The whole purpose of law is to create equality before the court. Yeah, but if you become, and I love you here, continue to concede, if you become super equal, if you become super equal in the legal system, right, you are now more equal than others. You are more equal than the judge, because now he cannot evaluate your particular trial. You are now more equal than the prosecution, because they cannot compete with your resource system. And any time we get close to finding out the truth, you can escape by simply saying, I won't incriminate, because going to jail is a bad thing. What we argue is having people who are criminals, who could potentially continue to commit the same amounts of crimes, is worse than those criminals going to jail, because we have to do a calculus that looks at the greater good. We're proud to propose this motion. We're proud to do it because we think it's in the best interest of the judiciary and it's in the best interest of the citizenry. Thank you.
I think the speaker for his remarks and call upon the member of opposition to extend the case for offense hearing.
Ladies and gentlemen, the reason why the burden of proof in criminal cases is beyond reasonable doubt is because the deprivation of rights placing a criminal record onto individuals, as the opening opposition suggests, but we would like to focus, that the deprivation of rights that happen onto individuals is so massively life-changing that, ladies and gentlemen, we cannot risk an innocent person going to jail. We think it was just not enough for the closing government to just say that we risk Enron every single criminal case that happens in status quo, not acknowledging that there are millions, if not thousands, ladies and gentlemen, of individuals in society that go through a criminal justice system that is weighed against them, that oftentimes, ladies and gentlemen, are stacked in regards to a system that doesn't allow them to defend themselves, doesn't allow them to know the complete information of the situation, and ultimately, even with a simple criminal record, have their lives entirely ruined because of that, ladies and gentlemen. We would rather letting that individual get off scot-free if we don't have to put through individuals who will rather be innocent and then creating criminals in the process on that side of the house. We would indicate that most of the time, a criminal justice system that is so eager to prosecute, as the closing government would like to suggest, creates entire communities that oftentimes fall to criminality because of those policies, ladies and gentlemen. We think that's exceptionally important. That's why the first extension that we directly engage in the material in the closing government is we think there's an underlying principle that hasn't been discussed in this particular debate as to why we think that we need to be very cautious as to how and when the information that we accept in the criminal justice system operates on our side of the house. Blah. Right. So, several levels of analysis. First and foremost, ladies and gentlemen, I think my POI at the start of this debate was exceptionally important. We don't think it got sufficient response from the opening government. Because the reason why it's important that the likelihood or the probability of whether or not the quality of the lawyers is in question, or the difference in the quality of lawyers, or the ability or the scheduling conflicts of lawyers between private and public counsels, are all a subjective matter in which it's presumptive on the part of the government to assume whether or not these things happen or not. We even might concede that it's likely that public counsels have a heavier schedule in comparison to private counsels, ladies and gentlemen. But why isn't that good enough in this particular debate, ladies and gentlemen? Because the burden of you taking away a right onto individuals in order to not incriminate themselves in the court of law and accruing consequences that might affect them lifelong, ladies and gentlemen. Grant on that side of the house, even the smallest of crimes can create criminal records that might prevent you from getting a job, get you incarcerated, mixed in with criminals, and definitively ruin your lives on that side of the house. That means that we can't rely on the simple likelihood, on the balance of probabilities on that side of the house to deprive individuals of fundamental rights that determine whether or not they will be able to survive for the next few decades of their lives. We think they just simply haven't met the burden of proof on that side of the house to deprive individuals of rights just on a simple likelihood that perhaps sometimes, maybe some counsels will have sometimes less scheduling conflicts on that side of the house. We think that's exceptionally important for us to acknowledge in this debate. But secondly, ladies and gentlemen, we think it's very, very important that in regards to comparing between guilty persons and innocent persons on that side of the house, the likelihood of individuals committing crime and the reason why we don't want innocent individuals falling into jails or having criminal records, especially when they're innocent, ladies and gentlemen, is that there's a balance, right? Individuals that have been we fail to prosecute but have been sent to court, and have been through trial, are oftentimes watched by the state, oftentimes on probation, or the state places some kind of precautionary or probationary period onto these individuals to ensure that these individuals are on watch. Or for example, the next time they fall into crime, these initial cases are oftentimes dragged up as used as evidence for bad behavior in the past. But the comparative is, if innocent individuals fall into a life of crime, or innocent individuals fall into jail, ladies and gentlemen, these are individuals that are more likely to fraternize with other criminals, fall to jail and have criminal records, after have their lives ruined and fall to crime as well. So the comparative isn't just we might let a guilty person go. We can control that more often than not, ladies and gentlemen. But the comparative is you more often than not create more criminals on your side of the house when you create a system in which you have innocent individuals falling into jails more often than not under that side of the house. That's the second level. But lastly, ladies and gentlemen, they told us we need to get a lot of information under the closing government, and that's why we need to not allow the imbalance and inequality that happens. Here's why I hear Leon, right? The reason is because oftentimes we allow individuals to lower that standard of deprivation of rights. For example, in the investigation period, ladies and gentlemen, because usually we allow officers to say get warrants on reasonable suspicion and not beyond reasonable doubt. Because at that point in time, you're just collecting information to make definitive accounts on whether or not there's guilt or not, and not direct and definitive judgments on whether or not a person will go to jail or not on that side of the house. The difference is, sir, is that in the investigation period, you can collect information and have more definitive proof as to whether or not a person is guilty or not, while not sending that individual to jail and not deprive them of rights. But the difference is on your side of the house, you're lowering the bar of evidence on that side in a period of time where the person will be definitively decided or to go into jail or not. That's why in principle, ladies and gentlemen, on balance, you need to place a higher burden based on these three levels as to when you want to deprive individual of rights, because we think it's exceptionally important, ruin individual lives because of simple likelihoods on that side of the house. Openings.
If you, as you apparently want, have the state profile, persecute and monitor people who have been found innocent, it seems like all the harms you're talking about would accrue to those people anyway, so I'm not sure how you're solving the problem.
Look, it's a precautionary thing, right? And obviously it's a comparative. We would rather have some precautionary probationary method, just like we do people who leave jail, as opposed to just completely depriving them of rights and sending them to jail on that side of the house. We think comparatively, that slight deprivation of rights is comparatively a lot better in comparison to sending people to jail. But secondly, ladies and gentlemen, after that first extension, I think we've sufficiently proven to you that the bar of the deprivation of rights under our side of the house needs to be met in order for you to deprive individuals of rights and send them into a spiraling life of potential crime, as well as, ladies and gentlemen, harm on that side of the house. We just think that the prejudicial value of this information, ladies and gentlemen, doesn't meet the standard of whether or not it will contradict truth. Opening opposition provides some value in regards to whether or not this will provide truth in the matter, but we think when you have public counsels have connection, prejudice, connecting with prosecuting teams, having tough on crime policies, and connecting with internal civil worker politics, ladies and gentlemen, where prosecutors pressure public defendants. We think oftentimes people need to have faith in the system in order to engage in that particular system, ladies and gentlemen. Ladies and gentlemen, at the end of this particular debate, you need to have a higher bar in order to deprive individuals of rights, in order for people to have faith in the system and not be deprived of their rights at the end of the day. Thank you.
I thank the speaker for his remarks and call upon the proposition to conclude the speeches on site judgment today. Here.
Our position as a bench completely undermines the power of having private counsel on the side. And this is unfair because they then take away the reality of the skills that these people obtain, the connections that these people obtain, but lastly, the availability to you and to serve you that you as an individual have immediately when you have private counsel. Like when you're arrested and you're kept in jail for 24 hours and you can call your lawyer to advise you there and then, whereas an individual with a public lawyer has to wait for longer hours to be advised in terms of what information they release in that space and time. These are things that affect the investigation process. These are things that affect the case prima facie, and we think these are things that ought to be considered in terms of the value of the case and the value of the information. So I'm going to analyze this debate using 3 simple questions. The first idea that we need to tackle in this debate is the nature of private counsels versus public counsels and why one is better than the other. But secondly, we need to also answer, can the courts or the justice system overall try to create substantive justice by taking away rights of other individuals and giving other groups special rights? But lastly, we need to look at the effects as well as the practical implications on certain individuals, which deals directly with the extension that we get from our closing opposition. The first thing that we need to consider, and this has been a big issue in the debate, is the idea of the nature of public lawyers and who gets to get public lawyers. And what we get from opening opposition is that, listen, the people that are most likely to get private lawyers are people that are really scared that they might be one day incriminated for something that they didn't do, so they invest thoroughly in legal professional help. And we say, one, this is not true, because a lot of people that are most likely to be profiled into performing crimes, right, which in most instances are previously enfranchised groups, are groups that have a lower income span, right? They have a lower income span. In most instances, they have to spend that income on basic needs, right? And they might view, or in most instances, they view legal profession or legal help as a luxury that they cannot afford, right? That's the first idea. The second idea is that in most instances, and in liberal democracies like America, private counsels are very expensive, right? So it's not something that you can, in most instances, just get. It's something that you need to be wealthy and have an income that sustains, one, your life, but secondly, that sustains a monthly pay to those people. And why is this the case? Because a lot of private counsels in America are based on reputation, right? The more reputation you get, the more expensive you get. So if you want the best private counsel, you need to have a lot of money in order to obtain that service. So comparatively, and in reality, the people that are getting a private counselor or people that are getting private lawyers are people that are in the higher income gap, and in most instances the wealthy group, right? Because of the social capital that these people have, right? So now that we know who exactly is getting getting the representation, we need to also adversely analyze who is not getting the representation and what representation they're getting. They're getting public representation. Now they argue, well, it's not that bad, but it is that bad because a lot of public lawyers go into public law, one, because they had no choice, but two, a lot of lawyers don't go into public law because there's no financial incentive. A lot of people see government, serving government, as not financially incentive enough, and what happens then is you have a few people and a few lawyers going into the public sector. That means you have a limited amount of human capital in that faction, right? But the problem is with high crimes in liberal democracies and in other countries, you then have a huge load of work in which they have to divide between a few individuals. What this does is it means the attention span that one lawyer gives to one case is usually limited, and the hard work they put in is limited, but they don't, the client is not the one that's paying them. So whether or not they win the case, it doesn't really affect their salary. But also they're very apathetic because they continuously work with people and they really don't care, or they don't have a financial incentive to invest as much into your case, right? So already you can, I'll take you in a minute. Already we can see that there's a disparity between the public and the private lawyer and the client and what benefits that they get. So now the second question is, should then the courts try to substantively make people equal in order to benefit individuals that are currently disenfranchised or harmed by the legal system? Yes.
Sure, but that doesn't actually end up impacting the outcome of the trial for that poor person who has to
Yes,
deal with public lawyers. It only
does.
does if you reweigh the balance so much that people would probably flood the public system, so those resources aren't available to them anymore.
Thank you. It does, right? Because when you have a nobody, right, in front of a judge versus Annalise Keating, right, already her reputation creates a brand in her matter. Already her reputation creates a brand in the court for her, right? That's one. Two, these people have connections within the system, structurally, right? They know judges. They were working under judges. These people have connections, and we argue that the judges system in that regard is most likely to trust them or value their arguments better than everyone else. So already, because of the connections and the and the history that these individuals have working in the system, already they are known and they have brands, and they've created a loyalty brand with judges, with prosecutors, that allows them to be at a higher level than anybody else. So what this means is the person who is rich, the person who is advantaged, is slightly above the person who is lower and who is already disenfranchised by the system, right? So what does this mean? It means, one, even if you're not guilty, you're less likely to be able to prove that or create doubt enough. One, because your lawyer is not well known. Two, he's not doing a very good job. Or three, he's not connected to anyone for anyone to value him that much. Lastly, he doesn't have that much of a reputation to make sure that he creates a case that, even if it is outstanding in some cases, a judge is willing to listen to. And the truth is, judges are not always impartial because they're human beings and because of human error. So we're arguing here that the richer person is slightly at an advantage more than the individual. And my speaker says in his extension, if you're wealthy and you're at a higher advantage, it's only fair to substantially equalize the field and the ground of trials, because in most instances, the system tries to be equals and ought to be equal, right? And the last idea that I'm going to deal with is the idea that we get from the last person, the last speaker, who says, well, you're going to take innocent people to jail, but in your process, you're taking innocent people to jail anyway because their lawyers are not persuasive enough, or they're not well known enough, or they're not doing a good job in protecting them. So in your world, comparatively, you still take innocent people to jail. In our world, we don't allow them to self-incriminate, and we allow the guilty people to incriminate themselves.
I think this would be from remarks of how the opposition went to conclude this round of debate.
She needs to go to the bathroom. I don't know if it's your call. It's your call.
I'll wait. I mean, it's it for me.
Too much water in the morning.
Intermission, part 2.
If only I had a second joker.
We also started so Eric's going to be so confused.
Well, there should be like an intermission, you know, in between the first half and second half. Right? I was thinking of that during the debate.
That's second. I think we're actually just being on these phones. Yeah. That's not true.
You guys all having fun?
Awkward small talk.
Oh yeah, this. I don't know which panel gets this second piece of paper.
What time is the Ooh, it's only Watford.
Presumably this is for bugs.
Classic Jason email.
Isn't this for bugs?
Oh, yeah.
One task a semester is to take students to the Lafayette Bay and the Madison School. One weekend is supposed to be helpful. You get an email, suddenly there's a lot of schools who are interested in a workshop is only available that weekend. Perhaps another chaperone can attend.
No way. A lot of
Which one is it? You can't go because you can't drive.
I go into
Door, a racist, sexist, door.
Yeah. I know. I don't want to.
I can't see it from here because your head is so large and your foot is quite folded. It's difficult to see around the rings.
He's like, maybe the best of it.
Okay. Right then. You're here.
Ladies and gentlemen, on site government, the debate seems to be a lot more about whether private lawyers are indeed people who we should trust, or whether we should have that amount of private lawyers, or whether people should have access to private lawyers, rather than whether or not the right against self-incrimination is a right that should have been exclusive towards people who access public defendants, right? This is particularly true in closing government, when they spent most of their speech telling us that the fact that people have private lawyers means that it's an unfair tactic, that some people get unnecessary advantage. We think that as mitigation, there are actually a number of methods in which we ensure that at least private lawyers are still operating within their job scope, right? So they cannot do things like hide evidence or encourage their clients to lie or falsify documents. That means that any extra effort that they do is actually in recognizing that the client is innocent or that in pursuit of actual justice, right? So as long as these private lawyers don't actually do anything that's against justice, we don't see why the extra effort is in any way wrong or not towards justice, right? So we agree on principle that there should be equality and in access to good lawyers and justice. We also think that there are a number of ways in which you can create good access to good lawyers, right? We also don't think that the presumption that all public lawyers are bad lawyers is a reasonable presumption. There are a lot of people, like for example, graduates from Harvard Law, who want to become private defenders and are private defenders, despite of the fact that they are overworked or things like that, right? So we think that if they really have a problem of things like overworking the public lawyers, then maybe not overwork them, or things like increasing the number of public lawyers might have been the solution. This would not have been my rebuttal if the debate wasn't about private lawyers versus public lawyers, but unfortunately that was what happened. So now I'm telling you how you can fix that problem. But let's move on to the real debate. No, thank you, right? Because the real debate was really straightforward, right? Because on their side, they wanted to say that more information is always better without evaluating how prejudicial that particular information can be. This is particularly important because if truly a justice system is perfect, we will admit all information possible. But the truth is that we recognize that judges are humans, that juries are humans as well. That's why we limit the amount of information to only information that are relevant, should be admitted in the court, and only information that are not prejudicial and wouldn't be unnecessarily prejudiced against the defendant to be admitted in the court of law. That's why we don't allow character evidence to be admitted in court for most criminal cases, because it might be incredibly prejudicial against the defendant. So we think that now we need to evaluate whether that information is particularly prejudicial. No, thank you. We think that Mirza already told you that the prosecutions are always pressured to create a conviction. That means that the examination of the accused are often prejudiced against the defendant. A jury is also more likely to be prejudiced if the accused answer that question reluctantly, accidentally answer that question wrongly, and things like that. So that means that the evidence is more likely to be prejudiced, more likely to hurt the defendant more than actually aid the justice system. So it's more likely that the evidence is either unnecessary because it's not a concrete evidence, just something a person said, rather than an evidence that we can use in court. But that evidence will unnecessarily hurt that defendant because the way in which the judge might perceive that evidence or the way in which the jury might perceive that evidence. So understanding that we've already established that it could be unnecessarily prejudicial, that means that it's a protection that every single person accused of a crime should deserve, regardless of how rich, poor, or what kind of lawyers this person have. Everyone deserves a right to that protection because everyone deserves a right to a fair trial, and a fair trial can only be achieved when you have that right. No, thank you. What would happen under our side? We think that under our side, we have a lot more people having faith in the justice system. This is something that Mibza already told you, that people need to have faith in this system. People need to understand that the justice system is not one-sided and not unbalanced against them. Not that the prosecution always have the advantage against them. This is how more people will cooperate with the justice system, more willing to give up information if they realize that that information won't be used against them in a prejudicial manner. So we think that the more people have faith in the system, the more people cooperate, the better it is. We think that the consequence of their policy, no thank you, are also very great, right? We think on their side, you deprive more people of rights, of presumptions that are untrue, on presumptions that private lawyers are always bad, and private lawyers are always people who coach their clients, or private lawyers are always people who have so many tricks that are illegal. No, thank you. The consequences of their policy is that you create more criminals and you deprive more people of rights, send people to jail, deprive them the opportunity to not have a criminal record just because of your mistake in justice. We think that's extremely bad. Before that, open.
As Omar has already conceded, sometimes this will help the defendant, sometimes it might harm the defendant, but in every case it will bring more information available to the jury and to the judges to actually find out what happened and give an accurate verdict. Why would that, on average, not be true that you get more information you can use to come to the right decision?
Look, the first question is why is that necessarily an exclusive situation towards private lawyers and not towards public lawyers as well? That is the first question. The second question is that why is it that more information is always good, right? There's a reason why we only admit a certain amount of evidence into court, because a lot of information is prejudicial against the defendant. So more information isn't necessarily good, when all those information don't work towards a better construction of justice, but those information are inherently prejudicial against the defendant. We think in order to create a better justice system, necessary protections need to exist, regardless of whether or not you are convicted or a crime. Because the presumption is that you're always innocent until proven guilty. Therefore, certain information that might hurt you but not necessarily create good evidence is not necessary to be admitted in court. We don't see a value in a person admitting certain things while he's on stand, just because the prosecution is crafty with the way they ask questions. But those things not necessarily mean that those are good evidence. But a jury or a judge might accidentally take that into consideration, given that the justice system isn't necessarily perfect. That's why we need to only admit evidence that are true, evidence that are unbiased, the evidence that will help in the pursuit of justice and not otherwise. We oppose.
I think I'll keep Mr. Remarks as you guys please.